All right, this is Copyright 2 Part 3, and we are still in these rights that we've discussed for all three capsules of the copyright holder. As we said, the copyright holder has these four main rights, right? There's more in Section 23 of the Copyright Act, but these are the four main ones that we look at in the textbook and for the course. And one of them, as we said, is the right to assign, which is not really a separate right as much as it is an expression of the fact that these three rights are not personal in nature, right? They can be assigned to someone else or a company in whole or in part, right? And we'll look at what it means to assign, and especially in the context of technology, which, as we said, creates specific challenges where two parties are acting simultaneously. And as we discussed in the first capsule, right, the textbook makes this distinction with the concept of authorization. Authorization is really not a separate concept, right? It's an expression of what it means to assign, right? Because at times you'll have a simple situation where I'm assigning my rights as a copyright holder. I write a song and then I can get paid for the song being played because that's my right to exclusive production and reproduction. I can assign that right to a company, for instance, and then the company will pay me a lump sum now, right, and will get the future revenue stream that comes from my song, right? In other situations, we can have two parties that are acting simultaneously. So instead of me assigning my copyright to another party, a person or a company, I can actually assign it in part such that the company keeps acting. And so I retain some of my rights and the company has a partial assignment of some of my rights. And so we're both involved in the situation. In that case, right, we can have multiple parties breaching the copyright. And we can have an even more bizarre situation where the second party has no rights, but helps someone infringe upon my copyright, right? It's kind of hard to understand because it requires very specific distinction of both extra-contractual liability and criminal law, which are kind of beyond the scope of the course. But all that to say, even if I don't pay someone or assign them my rights, right, they're just there, basically, and they help someone do something wrong with my copyright, then the person they've helped is not the only person that can be held liable. Helping the person can constitute, a violation in itself of my rights. So first, it's important to review basically two types of responsibility for other people. And again, I'm just explaining this here because it's mentioned in the book, right? And because it's used in some of the cases, but that's kind of beyond the scope of the course. You don't have to really understand that in depth, right? And so I'll take examples from two areas of law that illustrates the distinction that is important here. Torts, right, is also known as extra-contractual liability, right? So why can I sue someone? Well, I can sue someone because they have a contract with me that they've signed which creates obligations. And if they don't respect these obligations, then I can sue them because they've breached their contractual obligations. And I go to court on the basis of that contractual obligation. Well, oftentimes, someone is going to cause damages, right? Because again, why would I want them to perform their contract? Because it usually costs me money if they don't, right? Well, in a lot of situations, there is no contract, right? If someone pushes me off the roof of a building, say, in the United States, in a country where healthcare is not free, right? Then they cause damages, right? Because I have to go to the hospital and pay for it, and that is an extra contractual breach. They have breached an obligation which is not contractual, right? The obligation is a general obligation which is created in the law, right? That says even if you don't have a contract, you have to be reasonably careful. So if the person is not reasonably careful, is negligent, right? And then they cause, that's the second element, causation, damages, right? It costs me money. Then I can hold them responsible and get money. That's the broad concept. In some cases, you can be responsible for someone else, right? What if my kid goes out and bites another kid, and then that kid is hurt and it costs him money, right? We have causation with damages, and we have the obligation of my kid to be careful, which is going to vary with age. But in a lot of situations, right, we don't think that kids are actually smart enough to be responsible on their own, and we think that parents are responsible, either out of the fact that they control their kids, right, that they have responsibility for them and can kind of prevent them from doing things that are wrong, but also because parents have some negligence, according to the law, if the kid is careless, right? So if my kid is careless, it's probably because I haven't properly done my job to educate them properly, right? And in that case, right, if the kid causes damages, the parent can be liable. A third party who was not necessarily independently negligent, right, can be held responsible for the negligence of someone else. Here, my kid. It also happens in a corporate setting. It's what we call vicarious liability. My employee drives an ice cream truck, is careless and injures someone. Again, assuming we don't have a public regime that pays for all that, the person is damages and sues, right? Well, in that case, not only will the employee be liable, the employer will be liable. And in that situation, the employer hasn't really done anything wrong, right? The employer probably didn't even know that the employee was being careless in the truck. But still, the employer is liable. It's vicarious liability. I'm liable for the acts, the negligence of a third party, even though I have not independently done anything wrong, right? This is vicarious liability. Another concept, right, comes from the criminal law, right? What if I rob a bank, right? What does the law say? Well, the law says robbing a bank is illegal. If you do it, you can go to jail for a long time, right? What if while I am robbing a bank, I kill someone, but I don't plan to, right? And so that is not what we call first degree murder, because I did not plan on killing someone. It just kind of happened, right? I was running away, someone tried to block my way, I hit them, I thought I was going to injure them, but then I killed them. That is, what we call manslaughter. It's in unplanned but voluntary, murder, right? Killing of someone else. What if someone drives my truck? Well, in that case, we're both responsible, not just for what we plan to do, but from what actually happened, right? So if someone in the truck said, I'm going to rob a bank with you, right? But I don't want you to kill anyone because then I'll go to jail for too long. Well, in that case, they haven't planned on me killing someone, but they're responsible for the whole thing, right? And in that case, by virtue of the law, they have committed the crime because they've helped me. That's important, right? It is not my crime that is imputed to somebody else. Instead, it is both of us having committed the crime because we did it together. So it's not my actions being imputed to them. It says that was our common plan, and it's our fault that everything happened, so we're both responsible for having killed someone. The difference between those is in the first instance, right, I'm responsible for the acts of a third party, my kid, even though I did nothing wrong. The second case, right, me and my accomplice were both responsible for what happened because we both committed murder. So, again, this is beyond the scope of this course. You don't have to understand this in depth, but it's helpful to understanding the cases that we've read, right? The courts in the cases on authorization say authorization is not vicarious liability. If I help someone to violate someone else's copyright, right? So if I tell you, come into my house, we're going to photocopy this book illegally, and then we'll sell it and we'll split the proceeds. I may not have operated the photocopying machine, but I've participated in this common plan to violate the copyright, and so we're both responsible. Even though I didn't do the actual copying, which is illegal, I participated, I authorized, I aided you, and therefore we both are responsible for having violated the copyright of the copyright holder. That is like the example from the criminal law. We both did something wrong together. We're both responsible for having done the thing, regardless of who actually did the specific act that constitutes the violation, right? It's not like vicarious liability, because vicarious liability is, I did nothing wrong, my kid did, I'm still responsible. It's different. It's not a third party whose actions are being imputed to me. It's me and a third party. We did something together, we're both responsible. So, on assignment, right, if I do not assign my rights, and then two parties, right, are then illegally violating my rights, then they can both be responsible. Alternatively, this is not an important nuance, but if I've assigned my right to one party, and then same party goes beyond their license, goes beyond what they can do, right, and infringe upon my rights, and someone else helps them, they're both responsible. Because again, it's not because you have one of those rights that you have all of them, or that you can do whatever you want with what you're assigned. It depends on the nature of the right that you have, and if you only have a limited right, something else you do might be in violation of the other rights of the copyright holder, right? So this all comes down, so to take a step back, this all flows down from my right to assign and my right not to assign, right? So I can let someone reproduce my book if they give me money, or I can not do that, right? So consent is the important thing, right? So I can authorize these things, right? These things are violations of my right. Unless I've authorized them, then I've given consent, and then they're no longer violations of my rights, because I've consented to the violation of my right, generally because I get money. Similarly, if I assign my book, right, my copyright to someone else in whole or in part, well, then I've authorized them to take a part of my right and split the proceeds. That's also allowed because I've authorized them, right? I've assigned a portion of my right, and therefore they're not violating my rights because I've given them a part of it that they're exercising for me once it's assigned to them, or not specifically for me, but on their own behalf once it's been assigned to them, right? So we have these two cases on authorization, and what we're told is it is not really clear in technological context what it means to authorize a violation of copyright. So when two parties collude to violate someone's copyright, right? So what if, we have three examples in the book, they're actually pretty helpful, right? So what if a band performs a song illegally, right? So they're doing production that's not illegal. And then what if a third party, right, that's also not authorized, participates in that? What if the people who provide the concert room, right, they've also not been assigned a right to performance or to production, but still they're helping someone perform illegally. And then the question is, as the examples we gave, is it only the band that is responsible, or is it the people who provide the room which help the band violate my copyright? And the answer, as we saw, is the same as that from the criminal law. The answer is they're helping you, regardless of who does the specific infringing action, both people are responsible. Both people have violated the copyright, not just the person who did the specific thing that was in violation of my rights. But then, of course, there are situations where the person is not really participating, where they're just kind of there, right? And people aren't responsible for being there, right? If I commit a bank robbery and someone's just sitting, on the street and they don't actively call 911, well, that person hasn't helped me commit a bank robbery. They've just been there. And that is not illegal because it's not participating in my, unlawful act. Well, in that case, what if we have, a library that provides a photocopying machine? Well, providing a photocopying machine to everyone, right? And then there happens to be some very malicious person who comes into my library and uses my photocopying machine for mischievous purposes that violate someone's copyright. Well, in that case, right, that person clearly violated the copyright, but then I participated in that. And the answer is not really, because I didn't provide a photocopying machine to that person to do something wrong. I provided it to everybody, and I didn't even know, most likely, that someone did something wrong. And so I cannot have been engaged in the violation of the copyright. One of the more complicated similar issues is if you have a website, right? Let's say you own Facebook. Well, if you own Facebook, you know for a fact some people are going to say some very dumb things on Facebook and also say things that are illegal, right? Someone might say on Facebook, let's go kill the Jews. That's illegal for a lot of reasons, right? And that person has clearly done something wrong. Similarly, someone can violate copyright on Facebook. They can copy stuff illegally, right? In violation of someone's copyright. Again, that person has clearly done something wrong and can be held responsible. The question is, when does Facebook itself participate in that? And again, Facebook in that example is kind of like the library, right? Facebook provides a platform to everybody else in the same way that a park is a platform. And certainly someone in a park is eventually going to do something illegal, but in providing a park to everyone, you didn't contribute to that person doing something illegal. You just kind of provided a place. And in the same way, Facebook provides a platform for people to say anything, which will inevitably include things that are illegal or wrong. And in that case, Facebook cannot be responsible because they didn't help that person do something wrong. They just provided a platform for everybody to do it. And that's basically what the cases in that situation say, right? The case, the first case that we have, right, is the CCH case, which is the same one as we read before. And that's the case where we have this library, right, that's operated by the Law Society of Upper Canada, which used to be with the Law Society of Ontario, was called up until I think last year. And they have this library and they offer this very nice service where if you don't want to photocopy things yourself, they can do it for you and then send it to you, right? And then, of course, eventually, someone is going to use that photocopying machine to do something wrong. And so what does the Law Society do? They hang a sign upon their copying machine that says, if you do something wrong, it ain't our fault, right? And that essentially, in law, means absolutely nothing, right? Because there are things that you cannot consent to. I can't consent to be put in a cage in someone's basement. Because even though I have a right to consent as a general rule, that's against public order. I can't consent to you hitting me for the very same reason. And so when you go to rafting and they tell you that if you get injured, you're not responsible, that's worth absolutely nothing because you cannot consent to being hurt. Anyway, the Law Society does that, probably knowing that it's not worth much, and they put on their copying machine, if you do something wrong with it, you violate copyright, it ain't our fault, right? Well, then someone goes to court, right, and says they're helping people violate copyright. And this is a very peculiar case because there is not actually evidence that anyone violated copyright, right? So there isn't someone yet who has used a machine to do something wrong. The only thing that happens is they're saying, well, the sign that's there clearly admits that someone's eventually going to do something wrong, and therefore by putting a photocopying machine there, you are helping them. And what does the court say? Well, not really. And why is that? Well, the important thing in the case is that there is the person who puts up the sign, right? The person who puts the forum, the Facebook, or the photocopying machine, or the park is allowed to assume that it's going to be used for lawful purposes. So I can assume, right, until that presumption is rebutted, unless someone proves that I couldn't, in that specific instance, assume that, I'm allowed to assume that no one's going to use my photocopying machine to do something wrong. And therefore, my sign cannot be construed as an admission that someone will violate copyright because I legitimately assume that that will not happen. In fact, of course, the court goes further and applies some absolutely dashing common sense and concludes that the sign was actually put there to tell people not to violate copyright, right? It says, we ain't responsible if you violate copyright because we think it's wrong and we think you shouldn't do it. And so the sign is not, right, as the other side contended, an admission or an encouragement of people, violating copyright with a machine. Instead, it's an indication to people that they shouldn't do that because it's wrong. And that's why the Law Society of Canada does not want to be held liable, right? And of course, the court goes to this broader issue, which we've discussed many times, of the balance between, I won't repeat it, the public interest in disseminating ideas and works and the person's interest in protecting their copyright so they can make money and write things. And the court says, well, of course, it kind of gives too many rights to the copyright holder if they can just sue whoever put the photocopying machine there. Because of course, not only is that overbroad protection that upsets the balance, there's kind of a strategic concern there. Because of course, the guy who says something very dumb on Facebook is much less likely to have money to pay you than Facebook. And so whenever someone violates your copyright or says something wrong on Facebook, then of course you'll sue Facebook because Facebook has money, or at least you're sure that Facebook has more money than the guy, and so it's easier for you to recover. And that is overbroad protection, both because it gives too many rights to the copyright holder, but also because it holds people liable who haven't really done anything wrong. Back to the standard I've just said, right? The court says you're allowed to assume that the photocopying machine, or whatever else it is going to be used for lawful purposes until that presumption is rebutted, right? So what did the other side do? Well, they try to say that presumption is rebutted. They should have known. And what does the court say? Well, it's the Law Society of Ontario, so it would be fair to assume that the Law Society of Ontario wants copyright law to be respected and doesn't want to help people violate copyright law because, they're the ones who regulate lawyers. And of course, that's the court's conclusion that the presumption has not been rebutted. And that concludes it. The courts also get back to this specific issue we discussed, right, of control. And this is control different from vicarious liability. It's not the control from torts, right, that allows me to be responsible for someone else's actions. I give you the example of my kid, right? I can be responsible for the actions of my kid in some circumstances, even when I did nothing wrong. Well, it's not the same control. Court says control can be evidence that you participated in the mischievous act, right? Control can be evidence that you're part of the plan. And so even if you only provide the photocopying machine, if you have a particular relationship with the person who does something wrong, for instance, or they're your employee, or there's someone that you know very well and to whom you give instructions, well then, even if you only provide the photocopying machine, you might be part of the plan, right? And the presumption is rebutted, and we conclude that you've helped that person violate the copyright. We have this last case, which is the Society of Composers case, right? Which essentially, goes a bit beyond what we said. I've essentially summarized the important principles already because it's about internet intermediaries, right? And the court says something that might or might not be true, right? The court says the operation of the internet is a good deal more complicated than that of a photocopier. Maybe it was for the judge, I don't know if it is in actuality. Regardless, the court essentially says the same thing. If you have a website where people can post stuff, right? I gave you the example of Facebook. Back then, it might have been, just a website where you can download anything, upload anything, download anything. Well, then, of course, eventually someone's going to upload something there that they shouldn't, that violates copyright, but you don't know that. And again, for the same reasons, you're allowed to assume that people are going to use your website for, lawful purposes until proven otherwise. And so, in the case of an intermediary, the court develops a concept that is essentially the same thing, but it is particular to technological intermediaries. The court talks about content neutrality. And what does content neutrality means? It essentially means what I've just said. You provide a forum for everyone that is content neutral, right? You provide a park where people can do whatever they want with it, not just illegal stuff. You provide Facebook where people can say whatever they want, not just illegal stuff. And as long as you're content neutral, you're good, unless proven otherwise. That's essentially what the court says. And the court says, you can't really know you can't really know that people are infringing copyright. If you know, you should prevent them. But generally speaking, you don't know that a specific person is going to do it before they do it. But your responsibility, really, the court says, exists afterwards. So everything I said so far remains true. You can assume that people are going to use it for lawful purposes, and generally you're not liable when they don't. But once they do, you have to do your job, right? And so we're introduced to this system of takedown notices, right? That's what we have on the internet, on Google, on YouTube, on Facebook, and all that. If someone violates copyright, typically what will happen is the copyright owner or holder will call up the company and say, hey, this violates my copyright. Then the company knows. So the company's obligations extend there. The company has to be reasonably diligent, right? Once they've been told, they have to make a reasonable effort to make sure that the stuff that's infringing the copyright no longer does, usually by taking it down, hence why it's called a takedown notice. And so there's this obligation that's given more specifically, but that would also apply, beyond the technological context, for instance, in the case of our photocopying machine. And the court again states this concept of vicarious liability that still applies here. And so the internet provider, right, doesn't, by providing a forum for everyone, right, participate in the person's violation of copyright until there's a specific control of the person that is conducting the copyright violation.